Good morning. My name is Mark Bush. I'm an attorney in Portland, Oregon. My law firm is Mark L. Bush, PC. I've been representing residential landlords in Oregon for over 20 years, so I have quite a bit of experience advising landlords on landlord-tenant issues. I'm admitted in Oregon and California to practice law. By far the most common type of landlord-tenant dispute that I deal with would be the non-payment of rent cases, and that's simply because it comes up so much. Most landlords can handle that type of situation on their own with a little bit of training and the proper forms. But if you're new to this, make sure you get the proper forms for your particular state and get a little bit of training from either an attorney or a landlord management company, something like that, so you know how to handle it. In most cases it involves giving a non-payment of rent notice to the tenant, and then you have to follow through with an eviction action if that notice isn't paid. Another common case is a for-cause notice eviction case. That's where the tenant has perhaps damaged the property or hasn't kept it up. You give them a, say, 30-day for-cause notice that gives them a certain amount of time to fix whatever they've been doing wrong. If they don't fix it, then you're taking them to court. If they do fix it, they get to stay. Again, each case will be a little bit different, so make sure you have the right forms and you know what the law is in your state. One common issue that comes up from many of my clients is what happens if I sell the rental property? How does that affect me? How does it affect the buyer? How does it affect the tenants? In most cases, what will happen is the buyer of your property will step into your shoes as the new landlord. For example, if you have a one-year fixed-term lease and you sell it 6 months into that lease, the new buyer of the property will step into your shoes and have those tenants as his or her tenants for the next 6 months. If you happen to have a month-to-month tenancy arrangement, oftentimes you can give a no-cause notice either before or after the sale of the property if the new buyer perhaps doesn't want tenants or wants new tenants. So that's a little easier situation to deal with. But in any case, it's important to let the tenants know. Some states may have disclosure requirements requiring you as a landlord to tell your tenants. As a practical matter, it's good to let them know anyway so that you can get into the unit to show it to prospective buyers and the tenants aren't caught off guard when they're suddenly writing rent checks to a new landlord. Another issue that comes up quite often is how do I handle security deposits? How do I get them? Where do I keep them? And how do I get them back at the end of the tenancy? First and foremost is to get the security deposit before the tenants move into the rental property. There are situations where landlords perhaps make a payment arrangement to allow the tenants to pay the security deposit over a period of months after they're already in the unit. In my experience, that doesn't always work out because the landlord doesn't get the security deposit at all, making it more difficult to either get rid of the tenants or to cover the damages when they do move out. So make sure you get it up front before they move in. Some states require that security deposits be held in a separate account. Depends on which state you're in, so check with your local attorney on what the requirements are wherever your rental unit is. But in any event, the landlord will ultimately be responsible for that security deposit. So practically speaking, it's probably a good idea if you, especially if you own several rental units, to set up a sort of a trust account to keep all security deposits in so there's no mix-up as to where the funds are or how much is in the account at any particular time. Once the tenancy ends, most states will have a statutory set amount of time for the landlord to return the deposit to the tenant or to tell the tenant why in writing you're keeping the security deposit. In most cases it will be very important, say if it's 30 days in your particular state, it's very important to follow that timeline because most states will allow the tenant to sue the landlord for either the security deposit or perhaps twice the amount of the security deposit if you don't return it or tell them why you're keeping it within that amount of time. My clients often ask me what should be in my lease, and the first thing I tell them is make sure you have a lease that's particular for your state and your state's laws. Once you have that, though, there are several important provisions. First, make sure that you specify a definite term for the tenancy, whether it's a one-year fixed term, month to month, or in some states week to week. If it's not specified, usually by statute it will be defined as a particular type of tenancy, usually month to month. So make sure you get what both you and the tenant agreed on by putting it specifically in the lease. Another important provision would be the default provision. Make sure that your lease or lease form says landlord may terminate this tenancy for non-payment of rent, not following the rental agreement, or perhaps for some sort of outrageous act committed on the rental property. But it should most importantly include the term or as otherwise allowed by law. In other words, we can terminate for these reasons, and as otherwise allowed by law, it's sort of a catch-all. It allows you to rely on the full extent of eviction procedures in your particular state. Third is the security deposit provision. Make sure it's very specific on how much it is, when it's due, i.e. before they move in, and what it can be used for. And this is where the security deposit provision should say it can be used to remedy all defaults under the rental agreement. Some security deposit provisions don't include that language, which limits the landlord's ability to use it for any breach. Make sure you can use it for anything that might come up. Again, the most common type of case that I deal with and my clients deal with is the non-payment of rent case. The procedures for doing that type of case will vary from state to state, but almost in all situations you first have to give a written notice giving the tenant a certain amount of time to pay the rent to avoid having his or her tenancy terminated. A common example would be a 3-day notice to quit or pay the rent. Make sure you give that written notice if you are proceeding down this path. Make sure that the form you use is specific for your state, and make sure it's properly served on the tenant. In most states that will require either personally handing it to the tenant or mailing it to the tenant, usually by first-class mail, but again, check your state's statutes so that you know how to serve those notices. If the rent isn't paid within the specified amount of time, you're left with filing an eviction case in your local court. Follow your local court procedures. Usually you'll end up having to go to court for a first court appearance hearing where both parties have to show up. In many cases, judges will try to get parties to negotiate, say, a payment plan that the judge signs off on so that the landlord gets the rent, the tenant gets to stay, and if the tenant doesn't follow through on the payment arrangement, the landlord can follow through on the eviction process. If the tenant vacates or is evicted and still owes you money, whether it's for damages or for non-payment of rent, after the tenancy is over, usually the best way to proceed is to file a small claims action against the tenant. Typically doesn't merit hiring an attorney unless it's a large amount, but a small claims action can result in you getting a judgment against the tenant. After that, you can garnish the tenant's bank accounts or the tenant's wages if you happen to know where they work. In each case, it's really up to you to decide how important is it to file this small claims action, and even if I get a judgment, can I collect on it? That's something you have to answer before you proceed down that path.